All right, we're on the record in State of Ohio Plaintiff versus George Wagner IV, case number 2018 CR 155. The defendant is present in court with his attorneys, John Parker and Richard Nash. The state is represented by prosecuting attorney Rob Junk and special prosecuting attorneys Angela Canepa and Andrew Wilson. Also, special agent Ryan Scheider of the Ohio BCI&I is also present. We've been informed that the jury that's been deliberating all day have reached a verdict. Is the state ready to have the jury brought up for announcement of the verdict?
We are, Your Honor.
Is the defense ready?
Yeah.
All right, bring it up. You may be seated. Yeah, they should be brought up. Ladies and gentlemen of the jury, have you reached a verdict?
Yes.
Would the foreman please, or foreperson please hand the verdict forms to the bailiff here? I will now read each individual verdict. And after I've read each verdict form, I will ask the jury whether this is your verdict, and you should respond. If it is, you should stand up and make it known to the court. If it is not, all do appear to have all 12 signatures on every place that we would expect the jury to sign their verdict. Verdict as to count one, it says, we, the jury, find beyond a reasonable doubt that the defendant, George Washington Wagner IV, is guilty of aggravated murder as charged in count one of the indictment. It says, we, the jury, further find that the state of Ohio did prove beyond a reasonable doubt that the defendant, while committing the murder as charged in count one, have a firearm on or about his person or under his control, as alleged in count one, and specification one to count one. It says, we further find that the state of Ohio did prove beyond a reasonable doubt that the defendant displayed the firearm, indicated that he possessed the firearm or used the firearm to facilitate the said offense of aggravated murder as charged in count one of the indictment, as alleged in specification two to count one. It says, we further find that the state of Ohio did prove beyond a reasonable doubt that the firearm the defendant had on or about his person or under his control while committing the offense of aggravated murder as charged in count one of the indictment was equipped with a firearm, muffler, or suppressor as alleged in specification three to count one. Ladies and gentlemen of the jury, is that your verdict?
Yes.
Now, I'm going to shortcut a little bit on the next one, and the next few, but verdict, this verdict form states, we, the jury, find beyond a reasonable doubt that the defendant, George Washington Wagner IV, is guilty of aggravated murder as charged in count two of the indictment. And on the specifications, all three specifications are also found to be true by the jury. Ladies and gentlemen of the jury, is that your verdict?
Yes.
As to count three, we, the jury, find beyond a reasonable doubt that the defendant, George Washington Wagner IV, is guilty of aggravated murder as charged in count three of the indictment. All three specifications are also found with respect to count three. Ladies and gentlemen of the jury, is that your verdict?
Yes.
As to count four, we, the jury, find beyond a reasonable doubt that the defendant, George Washington Wagner IV, is guilty of aggravated murder as charged in count four of the indictment. All three specifications are also found to be true by the jury. Ladies and gentlemen of the jury, is that your verdict?
Yes.
Verdict as to count five, we, the jury, find beyond a reasonable doubt that the defendant, George Washington Wagner IV, is guilty of aggravated murder as charged in count five of the indictment. All three specifications as to count five are also found to be true. Ladies and gentlemen of the jury, is that your verdict?
Yes.
As to count six, we, the jury, find beyond a reasonable doubt that the defendant, George Washington Wagner IV, is guilty of aggravated murder as charged in count six of the indictment. All three specifications are also found to be true. Ladies and gentlemen of the jury, is that your verdict?
Yes.
As to count seven, we, the jury, find beyond a reasonable doubt that the defendant, George Washington Wagner IV, is guilty of aggravated murder as charged in count seven of the indictment. All three specifications as to count seven are also found to be true. Ladies and gentlemen of the jury, is that your verdict?
Yes.
Verdict as to count eight, we, the jury, find beyond a reasonable doubt that the defendant, George Washington Wagner, is guilty of aggravated murder as charged in count eight of the indictment. All three specifications to count eight are also found to be true. Ladies and gentlemen of the jury, is that your verdict?
Yes.
As to count nine, we, the jury, find beyond a reasonable doubt that the defendant, George Washington Wagner IV, is guilty of conspiracy as charged in count nine of the indictment. Ladies and gentlemen of the jury, is that your verdict as to count nine?
Yes.
Verdict as to count 10, we, the jury, find beyond a reasonable doubt that the defendant, George Washington Wagner IV, is guilty of aggravated burglary as charged in count 10 of the indictment, and all three specifications as to count 10 are found to be true. Ladies and gentlemen of the jury, is that your verdict?
Yes.
Verdict as to count 11, we, the jury, find beyond a reasonable doubt that the defendant, George Washington Wagner IV, is guilty of aggravated burglary as charged in count 11 of the indictment. All three specifications as to count 11 are also found to be true. Ladies and gentlemen of the jury, is that your verdict as to count 11?
Yes.
Verdict as to count 12, we, the jury, find beyond a reasonable doubt that the defendant, George Washington Wagner IV, is guilty of aggravated burglary as charged in count 12 of the indictment. All three firearm specifications are found to be true. Ladies and gentlemen of the jury, is that your verdict?
Yes.
As to count 13, we, the jury, find beyond a reasonable doubt that the defendant, George Washington Wagner IV, is guilty of aggravated burglary as charged in count 13 of the indictment, with all three specifications as to count 13 found to be true. Ladies and gentlemen, is that your verdict as to count 13?
Yes.
As to count 14, we, the jury, find beyond a reasonable doubt that the defendant, George Washington Wagner IV, is guilty of unlawful possession of dangerous ordnance as charged in count 14 of the indictment, with the two specifications as to count 14 found to be true. Is that your verdict, ladies and gentlemen of the jury, with respect to count 14?
Yes.
Count 15, we, the jury, find beyond a reasonable doubt that the defendant, George Washington Wagner IV, is guilty of tampering with evidence as charged in count 15 of the indictment. Ladies and gentlemen of the jury, is that your verdict? Count 16, we, the jury, find beyond a reasonable doubt that the defendant, George Washington Wagner IV, is guilty of tampering with evidence as charged in count 16 of the indictment. Is that your verdict, ladies and gentlemen, with respect to count 16?
Yes.
Count 17, we, the jury, find beyond a reasonable doubt that the defendant, George Washington Wagner IV, is guilty of tampering with evidence as charged in count 17 of the indictment. Is that your verdict with respect to count 17?
Yes.
Count 18, we, the jury, find beyond a reasonable doubt that the defendant, George Washington Wagner, is guilty of forgery as charged in count 18 of the indictment. Ladies and gentlemen of the jury, is that your verdict with respect to count 18?
Yes.
Verdict appealed as to count 19, we, the jury, find beyond a reasonable doubt that the defendant, George Washington Wagner IV, is guilty of unauthorized use of property as charged in count 19 of the indictment. Ladies and gentlemen, is that your verdict with respect to count 19? Verdict as to count 20, we, the jury, find beyond a reasonable doubt that the defendant, George Washington Wagner IV, is guilty of interception of wire, oral, or electronic communications as charged in count 20 of the indictment. Ladies and gentlemen, is that your verdict as to count 20?
Yes.
Count 21, we, the jury, find beyond a reasonable doubt that the defendant, George Washington Wagner, is guilty of obstructing justice as charged in count 21 of the indictment. The additional findings are, this has been, the additional findings circle that the crime or crimes for which the defendant intended to hinder the apprehension, prosecution, conviction, or punishment of another, or for which the defendant intended to assist another to benefit from the commission of, are aggravated murder, aggravated burglary, conspiracy, unlawful possession of dangerous ordnance, tampering with evidence, forgery, unauthorized use of property, interception of wire, oral, or electronic communications, or engaging in pattern of corrupt activity. Those have all been circled. This form does not circle. However, there's an indication here, we, the jury, further find that the state of Ohio did not prove beyond a reasonable doubt that at least one of the crimes for which the defendant intended to hinder the apprehension, prosecution, conviction, or punishment of another, or at least one of the crimes for which the defendant intended to assist another to benefit from the commission of, is a felony. So that is not circled. Was that an intentional thing? All right. So I don't know how
You
the,
need that.
I'm
That
sorry.
did or did not?
Yes,
Yeah, that's unintentional.
I'm sorry.
Unintentional.
Okay, so there was an intention to circle one of those.
Correct.
All right. And it's not. So how do we need to send them back down to the jury room to do that?
Perhaps we can approach.
Yeah.
Yes. We could have them retired out here. Said. I'll read the last one.
Yes.
We'll probably ask the jury to go back to the jury room for the purposes of completing that form, but let me read the verdict as to count 22 first. The count 22 reads, we, the jury, find beyond a reasonable doubt that the defendant, George Washington Wagner IV, is guilty of engaging in a pattern of corrupt activity as charged in count 22 of the indictment, and all three specifications as to count 22 are found to be true. Ladies and gentlemen, the jury, is that your verdict with respect to count 22?
Yes.
All right. Terry, do you want to have them go back down to the jury room? There's a spot on here where they are supposed to make a finding right there and express it on the jury form. Let's have them do that. And then see that they brought it immediately back up after they've done that. They should just stay in place. seated. All right. Again, the verdict with respect to count 21 states, we, the jury, find beyond a reasonable doubt that the defendant, George Washington Wagner IV, is guilty of obstructing justice as charged in count 21 of the indictment. To the additional findings, it states, we, the jury, further find that the state of Ohio did prove beyond a reasonable doubt that at least one of the crimes for which the defendant intended to hinder the apprehension, prosecution, conviction, or punishment of another, or at least one of the crimes for which the defendant intended to assist another to benefit from the commission of, is a felony. We, the jury, further find beyond a reasonable doubt that the following is or are the crime or crimes for which the defendant intended to hinder the apprehension, prosecution, conviction, or punishment of another, or for which the defendant intended to assist another to benefit from the commission of. And circled there, and the instruction was to circle all that applies, circle all in the brackets below that conform to your findings. What they have circled is aggravated murder, aggravated burglary, conspiracy, unlawful possession of dangerous ordnance, tampering with evidence, forgery, unlawful use of property, interception of wire, oral, or electronic communications, and engaging in a pattern of corrupt activity. Ladies and gentlemen, the jury, is that your verdict as to count 21 in your findings? Does counsel for either the state or the defense wish to have the jury polled?
On behalf of the state, we do not.
Yes,
Do I have, well, let me, I can't see your jury numbers. Maybe if you hold them up there for me. Let me ask juror number A194. Are these your verdicts and findings as announced by the court just now? As to all? Is that correct? All right. And A154, are these your jury, your verdict and findings as to all of the counts as just announced?
Yes.
A44, are these your verdicts and findings as to all counts as just announced?
Yes.
All right. And A243, are these your verdicts and findings as to all counts just announced?
Yes.
And A210, are these your verdicts and findings as to all counts just announced?
Yes.
A249, are these your verdicts and findings as to all counts as just announced?
Yes.
In the back, B20, are these your verdicts and findings as to all counts as just announced?
Yes.
A226, are these your verdicts and findings as to all counts as just announced?
Yes.
A105, are these your verdicts and findings as to all counts as just announced?
Yes.
A116, are these your verdicts and findings as to all counts as just announced?
Yes, sir.
A124.
A124, are these your verdicts and findings as to all counts as just announced? And,
A129.
all right, and juror A129, are these your verdicts and findings as to all counts as just announced?
Yes.
All right, is defense counsel satisfied with the polling?
thank you.
The court intends to set a sentencing hearing. I will have the court's assignment commissioner work with counsel for both sides. I would like it set, I think counsel felt like maybe it would take maybe a couple of weeks to organize a sentencing memorandum. So that would make it about December 14. We have the holidays coming up, so the parameters would be between December 14 and December, whatever the last work day is before Christmas. So in that period of time, the assignment commissioner will work with counsel in order to do that. At least 3 days before the sentencing hearing itself, I am directing counsel for each side to file a sentencing memorandum. It doesn't have to be, and probably should not be terribly lengthy, but it should cover whatever counsel feels the court should consider, and plus the recommendations of the state and the defense concerning the sentencing. Is there anything further from counsel for the state or counsel for the defense at this time?
Your Honor, I I know I made this comment to the court, but I would like an opportunity to speak with the jury. I know they don't have to, and I think the court is going to instruct them that way.
Yeah.
So, but I just wanted to make that known. I don't know how else to make it known.
Ladies and gentlemen of the jury, and this would include all of you, including the alternates, the court is not permitted to comment concerning a verdict of the jury. So nothing that I say should indicate the court's agreement with or disagreement with the verdict. That the verdicts are strictly in the prerogative of in the jurisdiction, I guess, of the jury. The court cannot comment on that, and I'm not commenting on that. However, your attentiveness and your dedication to duty have been noticed and are greatly appreciated by the court. I want to state something here for you, though, so that I make sure everybody understands this. You may understand it anyway. You are now released from the admonition not to discuss this case. You may discuss your verdict and your deliberations and your experiences as a juror with others, but you are not required to do that. You must decide for yourself whether or not you will discuss such matters. In the event, in any event, I guess I should say, whether you discuss them or not with others, you should be careful concerning what you say, whether it's to family members or discussing it with other people. You should make no statement, verbal or writing, unless you are sure that it is complete and correct. You should make no statement that you would not be willing to make under oath in the presence of the court or other jurors, or in the presence of the litigants and their respective counsel. In other words, don't just speak off the cuff and say something that you might later regret that you have said. If your statements are to the press, remember your name and your statement may appear in print. In which event you should be doubly cautious to be sure that your statement is absolutely correct, in whole or in part, because the press will use, or probably will use, only the part that the one reporting considers sufficiently newsworthy or challenging. But just remember that. Now, as jurors, you've served as public officers, really, of the court. When you're discharged, which will be immediately, and I leave the bench, your services are completed. And you'll be receiving some compensation, not nearly enough for the work that you did, but you'll be receiving that, and it will be mailed to you. It's my understanding we're mailing that compensation to, or the county. And you have all the rights of private citizens, all right? It's the lawyer's duty to protect those rights and to protect your desire not to talk about this case, if that's your choice, if that's your decision. It is improper and unethical for a lawyer or anyone else to harass, entice, or exert improper influence to you for the purpose of getting you to talk about the case. It is your individual choice whether you talk about the case. Does counsel for the state or counsel for the defense have anything further?
No, thank you.
Ladies and gentlemen, you are discharged. Thank you. According to this trial is adjourned.
Now, finally, I know, I saw my friend up there. Yeah, yeah. Thank you so much for all your work. I don't think that's all the girls behind us downstairs.
Make it all the way over there. Tracy's got a meeting, extra line item. James?
Always a perfect like that.
Yes.